Welcome back, COS supporters. It's another edition of COS Live. My name is Andrew Luce. I'll be your host. And of course, I'm joined by Rita Peters, my co-host, but also the Senior Vice President for Legislative Affairs. Rita, great to be back with you. How you doing?
I'm doing great, Andrew, and I'm excited to be back with you for another hearing today. A lot of states' legislative sessions are slowing down or have ended already, but not Ohio. We're still going there. So I'm excited to join you for this hearing today.
Yes, indeed, Rita. Ohio is still very much alive. Today, we're going over to the Ohio House Government Oversight Committee. They're going to be considering our resolution HJR2 and then HB 67, which is our 34 ready legislation. I know you're going to be talking about that in just a moment. Just to get our viewers caught up before we get into some of the details of today's hearing, 19 states have passed our Convention of States resolution. And it's under three topics: fiscal restraints for the federal government, limits on the federal government's power and jurisdiction, and then also term limits for federal officials and members of Congress. It takes 34 states to get to a convention. That's the magic number. Once we get there, delegates from across the country will go to debate amendments to the U.S. Constitution. So, like I said earlier, Rita, Ohio is very much alive, like you said. Rita, can you get our viewers caught up on what's going on in Ohio and what they can expect to see in this hearing?
Sure. Well, Andrew, we do have our COS application and 34 Ready bill introduced in both chambers in Ohio. So it's moving through the Ohio House and the Ohio Senate at the same time. Earlier in the year, we did bring you coverage of action from the Senate side in Ohio. They held both a sponsor's testimony hearing and then a proponents only hearing on SJR3, which is the companion resolution to HJR2. So the hearing that we're about to watch is on the House side of the Ohio legislature. In a recent episode, we did bring you the introductory sponsors only hearing from the House side. We didn't bring it to you live because there was so much going on at the time, but we did bring it to you after the fact. And typically, the sponsors only hearings are pretty brief, pretty perfunctory. The sponsors just really introduce the resolution or legislation to the committee, tell them what it's about, and then offer to answer questions. Well, on the House side this year, the sponsors testimony hearing was really long and involved, with the committee members asking a ton of questions. If I recall, it went on for over an hour, went into a lot of depth, and our House sponsors did do a great job. So today is the time for all of the proponents of our COS application, and again, the 34 Ready Bill HB 67. The proponents are going to have their day in the committee room to give testimony about why they support Convention of States. And alongside them will be Michael Ferris, our COS co-founder and senior advisor. He will be on hand to provide expert testimony. He is, of course, a constitutional attorney. He is a true expert on Article 5. He's taught a continuing legal education course for attorneys on the subject. He has published in the Harvard Journal of Law and Public Policy an article that definitively rebuts the claim that the 1787 Constitutional Convention was a runaway. It wasn't. And of course, he has a legendary track record of having been the former president of Alliance Defending Freedom, which under his leadership won 12 Supreme Court cases. He's also incidentally actually litigated an Article 5 case in federal court. So again, he is a true expert on the topic, and I'm so glad he was able to be in Columbus for this hearing today. I am hoping that the committee members who had plenty of questions to ask our sponsors at that sponsors only hearing, I hope they ask those same questions to Michael Ferris while he's on hand to answer them today. And in a way, I think this will be a mark of whether the committee members' questions are really genuine questions or not, right? Because they have a true credentialed, experienced expert on hand today to answer those questions. So you can see producer G has the footage up that's being broadcast right now from the committee hearing. It has not actually started yet. Once they do start, Andrew, there is one other bill on their agenda today before ours. However, it is not one with proponents or opponents, but it is on the sponsors only. So it's sort of just an introduction of a bill followed by questions from committee members. So I don't think it will take a ton of time to get through, which is why we wanted to go ahead and get started. In the meantime, let me give you a little bit more background information on Ohio's progress. More than 117,000 Ohioans have signed the Convention of States petition asking their state legislators to vote yes on COS. According to a study by the Trafalgar Group, almost 2/3 of Ohio voters, 62%, favor the state calling an Article 5 convention to propose constitutional amendments that limit federal spending, limit federal power, and establish term limits for members of Congress, maybe even federal judges and bureaucrats. This support crosses party lines with 71% of Republicans, 50% of Democrats, and 66% of those with other political affiliations, all supporting this effort for a convention of states. So I would say that's pretty convincing evidence that it is time for the state legislature to move this forward in Ohio. And today's hearing is a step in that direction.
Rita, when have you ever seen 62% of Americans agree on anything? I mean, this is really incredible to see how much support we have and across party lines. When have the parties ever agreed on anything? I mean, we can't even agree on no tax on tips and other things like that. So this is huge to see 62% of Americans, and then 71% of Republicans, 50% of Democrats, 66% of no political affiliation supporting a convention. I think the American people are just ready for some change, and they're ready for change that's not just superficial. They want real change that's going to impact the amount of money they have and their lives. So this is pretty incredible. Rita, so we're still waiting for the hearing to begin. Catherine Zemanek, who's the regional director for Ohio, she's going to be joining us a little bit later to give some analysis of what we saw in the hearing. Plus, she's going to be giving her perspective. So we'll get to her after the hearing. So you're going to want to stay tuned till after the hearing ends to hear from Catherine Zemanek. Rita, before we get into the hearing, we should do some legislative recap because it's been a while since we had a chance to give recap. So our Article 5 resolution was introduced in 23 states this year. And one of the big things that happened is Connecticut filed for the first time ever. That means that now every single state has introduced our Convention of States resolution. So that's a huge milestone for us. 8 states this year advanced COS in at least one committee. So that was South Dakota, Wyoming, New Hampshire, Kansas, Idaho, Montana, Texas, and North Carolina. 4 states passed in at least one chamber, either the House or the Senate. That was South Dakota, Wyoming, Kansas, Texas, North Carolina, and Kansas is carried over into the next year's session. And then Texas passed our Convention of States resolution with no expiration date, which was huge milestone for Texas. That sunset clause is now gone. So that's an update on what's been going on. It's been a really busy year, Rita. And you mentioned earlier 34 Ready. That's something we've been talking about quite often. Can we touch on 34 Ready just for a few moments and explain to our viewers what exactly that legislation is?
Absolutely. So these bills would set the rules for selecting and governing the commissioners that go to the Article 5 convention to represent the state legislature once the convention is called, pursuant to 34 state applications. And this year, 23 states have introduced that kind of legislation. We refer to it as 34 Ready because it's really all about the process of getting ready for that day when 34 state legislatures have made their application for a convention on the same topic, and we actually have convention. The states need to be ready for that day. And one of the things they need to do to be ready is to decide, well, how are they going to select their commissioners or delegates, and how are they going to go about the mechanical process of giving them instructions, telling them what they want them to vote for or not vote for. That is all the prerogative of the state legislature. So, again, 23 states just this year have introduced that kind of legislation, and we've seen victories in committees in 9 states on those. So, Montana, Indiana, South Carolina, Kansas, Oklahoma, Idaho, Iowa, New Hampshire, and North Carolina. 4 states have actually passed 34 Ready legislation this year in one chamber or the other: Oklahoma, Indiana, Montana, and North Carolina. And Indiana became the first state to successfully adopt our 34 Ready model legislation. And I'll just say a few words about that. So, a lot of states have already passed bills and have laws on the books already governing how they will select and instruct their commissioners. So we're by no means starting from scratch. But what we did last year was we had a team of constitutional and Article 5 experts develop a model set of legislation on this topic. And we're not insistent that states particularly use our model, but we provide it as a starting point for these state legislatures. And then they can change it however they want. They can decide that, instead of having 5 commissioners, they want to have 3. Or instead of having this kind of committee to oversee them, they're going to have a different kind of process. But what our model does, again, is it gives state legislatures a starting process for developing their own system for choosing and overseeing their commissioners. So that's what that is all about. I want to note here, you probably see the chair in the committee room. It looks like the hearing is getting started just a few minutes late today. And again, there is one bill that they will be taking up. If they go in order of the agenda, they don't always, but if they do, there will be one bill where they'll be just hearing from the sponsors on it before they get to our legislation. Now, our 34 Ready bill in Ohio is HB 67. So if they're talking about HB 67, they're talking about that mechanical procedural 34 Ready bill. If they're talking about HJR 2, that is our Article 5 Convention of States application. I believe Michael Ferris will give testimony, along with our supporters there in the room, will give testimony on both pieces of legislation because, of course, we do support both of those pieces of legislation. And just a little bit of behind the scenes information. I am told by Bill Scott, our state director for Ohio, that COS supporters have officially packed the hearing room. And in fact, Bill said if there are any opponents there, they'll have to stand in the hall because at this point, the room is filled with our supporters. Look at them there. You can see them with their buttons. Look at their smiling faces. I'm sure they're so excited to be there. I think I see Michael Ferris there on the left getting ready to give expert testimony. And I'll tell you one other little bit of behind the scenes information. One of our supporters who's there said, "Wow, it's quite amusing to hear people in the hallway say," and he quoted, "Wow, you can always count on Convention of States to pack the house. They show up everywhere, county events, you name it." So that is what is being said about our amazing grassroots in Ohio. And I know we hear similar things around the country. Isn't that just great to hear, Andrew.
Yeah, I love seeing packed rooms with our COS volunteers. I also saw Diana tell us there, giving a big old smile. So that was really great to see. Looks like there's still, I haven't moved on to our legislation just yet, so we'll hang out just for a few more minutes. I had a little technical difficulty, so I don't know if you jumped to F3 or not, but that's another thing that we do at Convention of States in several states, especially like the states where we've passed our resolution. We pursue F3 legislation, which is for freedom, federalism, and fundamental rights. We focus on bills that touch on those three areas, and it's another way of pushing forward with our mission, because our mission isn't just to get to a convention. It's a great goal that we have, but our mission is to grow a strong, engaged army of self-governing activists, and we do that every single day. We do it through our Article 5 resolution, through 34 Ready, but we also do it by pursuing F3. Rita, just for a few moments while we wait, can you touch on any F3 legislation that has worked its way through state legislatures this year?
Absolutely. Well, we've already had some successes with our team's F3 advocacy this year. Florida has enacted three F3 bills of ours into law, one enhancing immigration law enforcement, one urging the Secretary of Homeland Security to provide more training for immigration law enforcement, and one imposing criminal penalties for adults who enter the state illegally after evading immigration inspection. This one that I'm particularly excited about is in Georgia. The legislature passed SB 1, the Riley Gaines Act, which prohibits males from competing in women's sports, and also a state religious freedom restoration act that imposes the highest possible burden on any government action that interferes with religious liberty. In Indiana, the legislature has adopted SB 143, supported by our team, which bolsters parental rights. In Tennessee, the legislature passed the Medical Ethics Defense Act, prohibiting healthcare providers from being compelled to provide or pay for procedures that violate their consciences. Finally, the West Virginia legislature passed SB 299, prohibiting transgender surgeries and medications for minors. And that might not be a complete list. Again, in all of the 19 states where we've already passed our Convention of States application, our teams are always on the lookout for good legislation to advocate in support of federalism, freedom, and fundamental rights, and keeping with our overall mission of really building a culture of self-governance. And I'm so proud of those teams, Andrew. They do great
Yes.
work. And it's important too that they really keep their relationships with those legislators, because we're not going to be done once we get to 34 states passing our COS application. Then there will be the convention. And then presumably there will be amendment proposals that will need to go through the ratification process. So those relationships that our grassroots teams are building and then maintaining over time with their state legislators are just priceless. So
Mhm.
I'm really proud of them.
Yeah, I am too. And what you were just outlining there, all those different bills that we've supported, it just really shows that we're on the front lines of liberty. And we are pursuing, like you said, our mission, which is to bring about a culture of self governance. And, I just couldn't help but think about one of our buttons. And it says on there, the big COS button, it says more than a convention. And it really speaks to the fact that a convention is something that's really important. It's a goal that we have. It's part of what we do every single day. But ultimately, we are out there trying to restore the country, and we're doing it in more than just pursuing the convention. We're like you said, we're getting the states in those 19 states we've already passed. We're making sure that they're staying engaged, staying active in their state legislature, building relationships, because we're in it for the long haul. It's going to be sometime till we get to 34, and even after that, we have to have the convention, then ratify, and then we keep working at it, because a grassroots army never sleeps, a grassroots army never dies. We got to keep working on the front lines of liberty, because the tyranny is always trying to take away our fundamental rights, and tyranny is always working. So we need to be working just as hard, if not harder, to preserve those rights. Looks like we're still waiting. Going to be a few more minutes.
Yeah.
Um,
Andrew,
so
yeah, sorry, if I could just jump in. I just struck me that if we have viewers who are watching who haven't watched any of our coverage of the Ohio committee hearings before, you might be expecting a vote today. This committee will not vote today. And you also might be wondering, why does Ohio have so many committee hearings? So I just want to say a word about that. It is pretty unique. I don't know if I want to say it's absolutely unique, but Ohio does have a lot of hearings. Typically, they start, as we mentioned earlier, with a first hearing, which is just the sponsors introducing the legislation to the committee. That's what's happening right now with the bill that is up before the committee right now. They're just hearing from the sponsors. They won't take any public testimony on that bill. And then our legislation is next up on the agenda. After the sponsor's introductory hearing, the next stage in their process is to do a proponents hearing. And that is the stage at which the proponents for the legislation get to come in and give their testimony to the committee and make their appeal for why they want the committee to vote yes for the legislation. Now, I will note that even though you see an entire room packed with COS supporters right now, which I absolutely love, they're not all going to testify. They have very wisely chosen to limit their testimony. I believe they settled on 5 individuals giving proponent testimony after we hear from Michael Ferris, who is testifying as an expert. He'll probably take a little bit longer than they will since he is an expert. And hopefully, the committee members will direct most of their questions to Michael Ferris. So that's the point at which we are in Ohio in both chambers, in the House and the Senate. The Senate's already had its proponents' testimony hearing. Today, we're getting the proponents' testimony hearing in the House. The next stage, as we move forward in both the House and the Senate, will be the opponent's testimony hearing. And that's the one where Andrew and I are going to try really hard not to, take up our pitchforks and our torches. We're going to try not to bang our heads against the wall because we're sure that we're going to hear all the same old arguments that have been brought out time and time again about why the committee members should be afraid of a convention and why it's a terrible idea. And they're going to throw up all the dirt and dust they can about the process. Then after that, they will either let interested parties testify also in that third hearing where the opponents are testifying. That's what we hope they do. And then at some point later, the committee will then vote. So yes, Andrew, it is a long and drawn out and very deliberative process in Ohio to get through these committees, but I'm very pleased with the way it's gone so far.
Yep. Yeah, Rita, and I might end up being sick for the opponent testimony. I mean, I can't predict it, but I think I might be calling out sick that day. So, I mean, if I don't call out sick, I'll certainly get sick while watching that. It's terrible watching the opponent testimony. It just, like you said, it's the long drawn out arguments that have just they've never withstood the test of time. But people still listen to them and they take them seriously, even though we've thoroughly debunked them. The one that really drives me crazy, the one that drives me up a wall, is the one about Antonin Scalia and how Scalia was against an Article 5 convention. Well, they misquote Antonin Scalia because he says he was against a constitutional convention. Right, because when Justice Scalia was approached about this idea, of course, when he heard Constitutional Convention, he was thinking about what happened in 1787. He wasn't thinking about Article 5 of the Constitution, and so he was thinking, "Yeah, completely rewriting the Constitution would be a bad idea." But
Right.
he's often misquoted on that, and that one just really drives me crazy because we have the video proof of him defending the use of Article 5 and how it can actually achieve some real institutional change that would benefit Americans.
Yeah, and that quote that's taken out of context, if you look at the rest of the quote, he even says it's not a good time to write a new constitution. And that's not what the states get to do under Article 5. It's not about writing a new constitution. It's about proposing amendments to the constitution we already have, just like Congress has many times proposed amendments to the Constitution. Article 5 only gives the convention the exact same power that it gives to Congress, and it's only the power to propose constitutional amendments. So, yes, Andrew, it drives me crazy when people get that wrong. Do you have any other particular pet peeves when it comes to opponent testimony?
All of it. No, I
You're
think that
not
was.
allowed to be sick that day, Andrew. We're not
No,
going to
I
allow it.
won't leave you, Rita. I definitely won't leave you. I'll be there, going through the bad, the good. Well, there won't be any good, but the bad and the ugly. Other pet peeves. I think that one really is the one that drives me most up the wall. I guess calling it a constitutional convention is something that drives me up a wall. Because and what's funny is our opponents will all often say, "Well, convention of states, that language is not in the Constitution." Well, neither is constitutional convention. It says a convention for proposing amendments. So I just, our opponents, they really they point the finger at us, but they really should be pointing the finger right back at themselves,
Yeah.
because they are always misrepresenting what is inside the Constitution, what it says. Rita, while we're waiting, Producer G does have a 2-minute video of you answering questions from the committee members, it looks like. And I think we should roll that and then do some commentary on that. And then we'll see if that if they've wrapped up the what they're talking about and moved on to our legislation.
Would like to invite Steve Jones.
Okay.
Steve Jones.
Oh, here we go.
Oh, here we go. Never mind.
Yep. Welcome to committee. You can begin when ready. This is House Bill 67.
Thank you, Chair Hall, Vice Chair Ferguson, Ranking Member Humphrey. My name is Steve Jones, and I'm from House District 56. I first signed a petition in support of an Article 5 Convention of States back in the fall of 2013. Today, I'm here seeking your support for House Bill 67. It's my joy to provide proponent testimony in this committee for our companion legislation. In 2019, my then representative and my senator both requested that I provide some sort of delegate or commissioner's selection and conduct legislation for any or all conventions of states. So what I did is I studied all of the other states, what they had done that had written something up to that point. And then I kind of from scratch wrote something on my own and then shared it with my legislators, and they were satisfied that I had addressed their concerns about establishing a process for both selecting and controlling delegates. However, today, we're not...
Mr. Jones, I'm so sorry. Can you press that green button on your microphone? There we go. There we go. Sorry about that. I wanted to make sure that your audio was being recorded.
Okay. Please tell me I don't have to start over.
No.
Okay, very good. House Bill 67, however, was composed by people much smarter than this plumber you see before you today. House Bill 67 provides procedures regarding the selection, the instruction, the oversight of commissioners to any Article 5 amending proposing convention. It includes criminal penalties for any commissioner who violates their instructions. Frankly, this companion legislation should have been passed by the legislature immediately after passing the Balanced Budget Amendment Article 5 Convention resolution. This common sense bill is long overdue. It provides a process which requires the delegates be faithful to the wise opinions of the Ohio legislature and common sense Ohioans. First, I would like to note that HB 67 cites in lines 13 and 20 that the authority for any Article 5 convention is under, and I stress the word under, Article 5 of the Constitution. The topics to be discussed must conform to the scope of the originating resolution and call of that convention. States like Ohio are only discussing proposing amendments. Article 5 already outlines the ultimate methods of ratification to any amendment proposal. And that second, all of the authority to select, authorize, discipline, recall, and replace commission delegates resides with the General Assembly. And I've listed out the lines where you can find that, or the advisory committee. Congress, United States Congress, will not be choosing or controlling our Ohio delegates. Our governor will not be choosing or controlling Ohio delegates either. Very soon, you may be approving House Bill 67 to move to the floor for a vote. Your fellow representatives and all of Ohioans deserve for you to pass HB 67 out of this committee. The people want to know that the Ohio legislature has a process for selecting convention delegates and to keep those delegates on the straight and narrow. Human nature is corruptible, but this legislation will help create and ensure a good system that places adequate checks on ambition and avarice, which will protect Ohioans and all of America. I now ask you to support both HJR 2 and HB 67.
All right, thank you, Mr. Jones. If you could stay up there, we might have a few questions for you. Representative Gross.
Thank you, Chair Hall. Thank you, Mr. Jones. We have been friends since homeschooling.
Yes, ma'am.
Thank you for being here today. My question is, since in your testimony you stated that HB 67 provides procedures regarding the selection and the instruction and oversight of the commissioners to an Article 5. Sir, I'd like you to explain to me, could a convention change its own rules if it was convened? And then secondly, who would have the authority to chair that convention and who would set the rules in order?
Well, that is not specifically germane, though, to HB 67. HB 67 is specifically about the delegate selection.
Follow up, but in your testimony, sir, you did say that HB 67 provides procedures regarding the selection and the instruction. So I wondered what your thoughts were on could a convention change its own rules once it was convened?
That is not what was stated, Chairman. The legislation, HB 67, specifically is so that Ohio can choose their commissioners to attend.
Follow up.
No, sir, thank you.
Okay, thank you, Representative Gross. Representative Rader.
Thank you, Mr. Chair. Thanks for being here, Mr. Ferris. Is there anything in this legislation that would prohibit the General Assembly from selecting members from excuse me, I'll get up on this mic here. Anything in the legislation that would prohibit the General Assembly from selecting delegates all from one party?
I believe there is nothing specific, Chairman.
Okay.
Follow?
No, that's it. Thank you.
Any other questions for Mr. Jones? Seeing none, thank you so much for your testimony today.
Thank you.
Next, I will call up Dr. Michael Ferris. Dr. Ferris, I see that you submitted proponent testimony for this and HJR 2. We'll do 67 first, and if you could stay up there, and then we'll move to HJR 2, if that's okay with you.
Thank you, Mr.
I
Chairman.
believe
We
there's
have-
only two in-person testimony for HB 67. So
Thank you.
proceed when ready on House Bill 67.
Mr. Chairman Hall, Vice Chairman Ferguson, Ranking Member Humphrey. Again, my name is Mike Ferris. I'm a constitutional lawyer. I'm the co-founder of the Convention of States Project. In addition to having practiced constitutional law for getting close to 50 years. Next year will be my 50th anniversary. I also have taught constitutional law at the collegiate level for 17 years. I have also, one of the few lawyers in the country who's actually litigated a case about the amending process involving the efforts of Congress to change the rules for the ratification of the Equal Rights Amendment. I litigated that back in the 70s and 80s. This bill is a bill that should be supported by everyone, regardless if you think it's a good idea to call a convention or not. If there's ever going to be a convention, whether Ohio participates in being one of the 34 states that calls a convention, if a convention's called, you're going to have to appoint delegates. You're going to want to be represented in that. You don't want to be absent. So how are you going to name your delegates? How are you going to control them? What's the process going to be? That's all this does. It has no bearing as to what the topic is. HJR 2 is about a topic. This is not about a topic. Whether it's term limits or this or repealing the Citizens United that some people are working on, it applies to every convention on any topic at any time. Now, there are three key principles. One is the delegates are appointed and controlled by this body. That's historically accurate way to do it. In the 1787 Constitutional Convention, every state gave their delegates instructions, and those were followed. Two quick examples. New York gave its delegates instruction that all three delegates had to be present to vote. About July of that year, two of the delegates got mad and went home. Alexander Hamilton stayed. Hamilton continued to debate, but New York was never allowed to vote again because New York's instructions from the legislature were all three had to be present to vote. So New York stopped voting when those two delegates left. The other example, Delaware said that there had to be a system where the states were equal. And so the convention followed that. Was one of the reasons that the bicameral process was created, with the Senate being equal states. So the delegation from Delaware under instruction from their legislature, which was followed by the convention, is an example of this. So whatever the state tells its delegates to do, that state is entitled to see that that's enforced. So second is that I've already covered this actually, it applies to any convention whatsoever. There are two key rules for a convention that people are legitimately concerned. No right-thinking person wants an unlimited convention where you can propose any amendment on any subject. I don't know anybody, right, left, or center, that wants that. There may be some radical person someplace. I've never met them. The two key rules are this: you can't change the subject at the convention, and secondly, it's one state, one vote. I'll cover the you can't change the subject matter in my second testimony if I can, but you can't change, the one state, one vote is also very important. There are penalties attached to this that are both removal of the person and criminal prosecution if there's a deliberate defiance of the limitations imposed by this legislature. And with that, Mr. Chairman, I would be glad to answer any and all questions that you might have about this.
Thank you, Dr. Ferris, for coming in today and for your testimony on House Bill 67. We'll first go Representative Gross and then Representative Stevens.
Thank you, Mr. Chair. Thank you, Mr. Ferris, for being here. I was a decades-long member of HSLDA, and I appreciate all that you've done for homeschooling in the United States in your tenure. With regard to your testimony today, my understanding that at a convention, the delegates become federal agents and that they are sovereign once they get to DC. How would you suggest that Ohio would enforce our laws against a federal agent during an Article 5 convention?
Well, Mr. Chairman, to the representative, your information is incorrect. They are not federal agents. The delegates are representatives of the state appointed by and controlled by the legislation. There's no history, there's no legal precedent. They're agents of the state. And the recent Supreme Court decision in 2020 of the Chiafalo versus Washington relative to electors, members of the Electoral College, the Supreme Court of the United States clearly ruled that the electors are controlled by the states. The rules that are set by the state legislature must be followed by the electors. There's no basis for saying presidential electors are state controlled, but members of a Article 5 Amendments Convention are not state officials or state controlled personnel. They're identically from a constitutional perspective.
Follow up.
Thank you, Mr. Chair. So since we can appoint anyone, and we liked Taylor Swift last year, we could appoint Taylor Swift as one of our delegates. And what you're saying is if she was an Ohio state resident, that once she went to DC, that we would be able to enforce Ohio law at the federal level.
Mr. Chairman, Representative Gross, there's a difference between constitutional activity and federal activity. The Second Amendment is a federal constitutional right. That does not mean that Congress acquires the ability to regulate guns because there is a federal constitutional right. You have to look to an enumerated power of Congress to claim the right to regulate guns. The First Amendment protects freedom of speech, freedom of religion, freedom of assembly, and so on. That does not mean that Congress has the authority. In fact, it says to the opposite. Congress shall make no law relative to these things. So there's constitutional level issues and there's federal level issues. There are statutory level constitutional issues. There are regulatory level constitutional issues. There's executive branch constitutional issues. The word federal is not all encompassing, that anything that has the word federal attached to it is controlled by the same process. This is controlled by Article 5 of the Constitution of the United States. These are conventions of states controlled by the states, appointed by the states. The whole purpose of Article 5, this aspect of Article 5, was to give the states the unilateral ability to override federal abuse of power, and the federal government has no substantive say in the matter. The states were given and control a unilateral process. And the fact that there's so much federal overreach, and every state legislature in this country debates day in and day out, we got to comply with this federal regulation, we got to comply with that federal regulation. Every single one of them, I would submit, almost every one of them, is unconstitutional. And you should be resisting that, not complying with that. And this is the process that you throw that kind of tyranny over permanently. And so to say that they're a federal constitutional appointed person does not mean they're subject to control by Congress or the president or the executive branch or any agency. Just not how you read the Constitution. It's not how the Constitution works.
Representative Stevens.
Thank you, Chair. Thank you for being here today. The question I have about this particular bill is it seems to be, of the delegate says what they can and cannot say. And my question is that even constitutional in the first place?
Mr. Chairman, Representative Stevens, there is I've argued a free speech case in the U.S. Supreme Court, so thank you for the nice question. There's government speech and then there's individual speech. When you're acting as a government agent, you have less leeway than you do when you're just a free citizen. Free citizens can, public school teachers, a lot of free speech, not total free speech. Other agents of government, not a lot of speech is free, not everything is free. And so to the extent that they're controlled by the government agencies, then what the bill reads is you can't promote a topic that is basically non-germane. That's the free speech limitation I see. If you see another one, maybe I've missed something in the drafting of the bill. But if it's simply saying you can't advocate something that's illegal, it's basically you can't bring up an objectionable topic. It's not designed to control the content of your speech, but basically speech that becomes action, and speech that becomes action is a different level of free speech analysis than pure speech. So if you can clarify the question, maybe I can put a finer point on it, but that's the general principle.
Oh, absolutely.
Yeah, I'll follow up. I mean, my concern is the way with this bill is written is that if somebody's in the hallway and they start complaining about their property tax bill or the weather, it's not listed as things they're allowed to speak about. It just feels like the way the bill is written will very limit, and just normal conversations could be criminal under the way this is written.
Mr. Chairman, Representative Stevens, I don't think that a bill would ever be interpreted for hallway conversations. I would assume that what it means is when you're acting in your official capacity, standing on the floor representing the state of Ohio. And if it doesn't have that limitation, then an amendment would be appropriate to make sure that that's taken care of. Because if that's the concern is quite legitimate. But I don't think it reaches that, but I'd be glad to work with you and perhaps propose an amendment.
Thank you, Representative Stevens. Let's go Representative Rader, and then we'll come back to Representative Gross.
Thank you, Mr. Chair. And thank you, Dr. Ferris, for being here. And I apologize, Mr. Jones, for getting the order wrong and the names wrong. So my apologies. But pretty much the same question. I know you didn't write the bill, but maybe you can speak to this idea of proportionality of the delegates. Maybe why wouldn't that be addressed when, this could pass 51 to 49, right? And then that 51% that got to pass this piece of legislation can then choose all the delegates, essentially. Why wasn't proportionality addressed? Is that something that we should really look at?
Mr. Chairman, Representative Rader, proportionality was not addressed because it's something that the legislature would need to consider when you're looking at appointing delegates to a particular convention. I would guess that it would matter to you what the topic of the convention is when you're going to discuss proportionality. And I don't think that putting handcuffs on you on things that may vary would be something you put in the bill that is done every single time. These are the minimums. You can add additional criteria when you're working out a deal to appoint, we're going to send 7 delegates. Here's how we're going to do, here's how we're going to balance our ticket, or we're going to do whatever. Those considerations will be done in real time for each thing, and it would depend on the topic, I think. And so rather than hamstringing you and making you do that every single time, you can do whatever you want to do that would be relevant to the topic at hand.
Follow? Nope. All right, Representative Gross.
Thank you, Mr. Chair. Thank you again, Dr. Ferris. I was just wondering, James Madison said they didn't need to come back to the states. How would you answer James Madison today?
Well, Mr. Chairman, Representative Gross, James Madison, if I have the right quotation, I have read and written a lot on Madison's work, was talking about whether or not they should have a second general convention immediately after the 1787 convention. I named a college after Patrick Henry. I'm the founder of Patrick Henry College, and he was debating with Patrick Henry over whether Virginia should ratify the Constitution and then seek amendments, or first have a second general convention and then ratify the Constitution. That was the debate in Virginia. And Patrick Henry narrowly lost that debate. Madison won that debate. He didn't want an immediate second general convention. And he was right about that. But the upshot of it is because there was a genuine process to get Article 5 to get a convention, and Virginia immediately called for a convention once the Constitution was ratified. So the first ever call for an Article 5 convention, which calls it in that document a convention of states, was by the Patrick Henry forces, and they called for a convention. Basically, that gave us a Bill of Rights. They asked for a couple other things. They didn't get everything they wanted, but we got the Bill of Rights because there was an application for an Article 5 convention, and Madison had given a promise to the Baptist churches in Orange County, Virginia, that he would go ahead and bring the Bill of Rights forward as a congressman. He won their vote as a result of that promise. And so Madison was right in context. And so it doesn't mean you don't ever amend the Constitution. He helped write it. He helped use it. And so taking a cherry pick quote like that is like taking the verse that said Judas hung himself and go thou and do likewise. You're taking two things together way out of context. Nobody told you from the Bible to go hang yourself. That would be a misuse of scripture to do that. And it'd be a misuse of Madison to try to twist it and expand it beyond its context.
Yeah, last question.
Thank you, Mr. Chair. So since you brought up the topic of multiple conventions, your colleague, Mr. Santorum, is on record and was recorded stating that we should have an Article 5 convention every 5 years. How would you answer that question?
Mr. Chairman, Representative Gross, obviously nobody can control how often a convention would be called. It's very hard to do. It's extremely hard to do. This has been going on for about 12 years of my active participation in the process. And so if it could be, I doubt that everything that I would like to get accomplished, I think the federal government ought to be restricted pretty strenuously or restrictively. I'm not sure that it all get done in the first one. And so I would be open to having a second one once America sees how the process works. Because the best thing that comes out of a convention like that works and works safely is the states know they've got a weapon in their arsenal now that balances out their power against the federal government. No longer are you guys the minions of what people in Washington want you to do. You're the parents. And my wife and I have 10 children. 31 grandchildren, 1 great grandchild. You take over America your way, we'll take over America our way. I think I'm an expert on what would happen if you didn't discipline your kids. If you discipline your kids, you're gonna get good kids. You don't discipline your kids, you got a mess. The states are the parents. And for 250 years, we failed to discipline the kids. Well, this is time for the parents to get in charge and tell the feds, you guys are the kids and we're going to take away your credit cards and some other stuff. And that's the best thing that can come out of this. And if it's every 5 years, every 7 years, George Mason gave us this methodology because he said someday the federal government's going to abuse its power. And if you think the federal government's abusing its power, let's do something about it. And if they continue to abuse their power, let's do it again. But we should do it as often as the federal government abuses its power. Once they stop abusing their power, we don't need to do this anymore.
Thank you, Dr. Ferris, for your testimony today. Stay right there, though. Last question.
Thank you, Mr. Chairman. Thank you for your testimony today. Speaking of disciplines, so what happens to a delegate who doesn't follow script? What is the recourse for the states?
Okay. Mr. Chairman, Representative Sims, I want to address technically the word script and then address your question. There is no script. There are things that are off topic. And the basic instruction of this state to the delegates is stay on topic. If you're sent to do fiscal restraints and term limits, you don't bring up changing the process for the Electoral College, okay? You stay on topic. Whatever you're told to go and do, you stick to the topic. So you can't, with integrity, give them an actual script. They should be given the marching orders that says you will stay on topic, you'll be faithful to the command that you've been given, and with that, you let them go and be responsible representatives of the state who will have the freedom to debate and think through things and hear arguments from other states and make good decisions. That's the process that this will be about. And but if they violate the rules and they go off topic and start pushing things that are outside the zone, then you can recall them. And if it's purposeful, you can criminally punish them. That's what the bill specifically says.
Seeing no further questions, that will conclude the second hearing on House Bill 67. Again, stay right there. I'll now call up House Joint Resolution number 2 for its second hearing. And Dr. Ferris, you can begin testimony on that whenever you would like.
Mr. Chair, Vice Chairman Ferguson, Ranking Member Humphrey, thank you for the opportunity to stand in support of House Joint Resolution 2. There are 3 stages of an Article 5 process when you're using the convention methodology as opposed to Congress proposing amendments. Stage 1 is setting the agenda for the convention. And that's done when 34 states, 2/3 of the several states, agree on the topic. There have been 450, in round numbers, applications for a convention of the states in the history of the country. We've never had one, even though there are well more than 34 states have asked for a convention. And the reason we've never had one is because 2/3 of the states have never agreed on the topic. There is a binding historical precedent from the actions of the collective actions of the states in Congress that you've got to have an agreement on the topic or you don't call the convention. That's how it works. The second, and it takes 34 states to do that. At the convention, you draft the language. So the second stage is the drafting stage, where you actually write the text of the amendment. In this case, what will the fiscal restraints look like? What I would argue for is 3 components. There's a balanced budget rule, a tax limitation rule, and a federal spending rule that can't exceed spending and taxes and so on. So but you write the actual text. Then that's 26 states. It's a majority of the states voting one state, one vote at the convention. Stage 3 is ratified, 38 states. Congress gets to decide whether it's by state legislatures or by state ratification conventions. They've only chosen the state convention methodology once, so presumptively it will be Congress would choose to send this to the state legislature. 38 states have to ratify. So any concern that anything crazy gets through that system, people can count votes. How in the world are you going to get 38 states to do something crazy? Right-wing crazy, left-wing crazy, it doesn't matter. Crazy stuff doesn't get ratified by 38 states. So next, the question is, why are the topics binding? Well, we learned that the topics are binding to start. The question is, could you change in the middle of the stream? Well, I mentioned the case of the presidential election case from 2020, but even more pertinent is the ERA litigation that I did in the 70s and 80s. I filed the first lawsuit challenging the constitutionality of the act of Congress to change the deadline for ratification from 7 years to a date certain. It was about 10 and a half years. They gave it about an extra 3.5 years to ratify the ERA. And the federal district court in that case ruled you can't change the rules in the middle of the stream. It went to the Supreme Court of the United States. The second deadline timed out, and the Supreme Court said the ERA is dead, the case is moot. It was brought back again when 3 states tried to purport to ratify it in more recent years. And that has been litigated again, citing the case that I litigated back in the 70s and 80s in Idaho. Others joined that. I filed the first one, and I represented Washington. Others represented Idaho and Arizona. But citing the case I helped to litigate, the federal courts have repeatedly ruled, every judge appointed by every president, Republican and Democrat, have ruled you can't change the rules in the middle of the stream. 7 years means 7 years, and the changing the rules for the ratification process. So the idea that a convention can change its rules, of course they can change the rules about how often you debate, about, where do you sit, and there are things that you can change. But there are some things you can't change. And, the Republican National Convention can't change its rules and name the Democrat candidate for president. You can't do it. Can't pass laws for France. And so the convention can't do what the states are not allowed to do, and that is it can't change the topic. 34 states agree on it, and it is fixed. The final thing I'll just very briefly, in the light of the time, there are people who are conservative like I am, who argue that the best evidence that it would run away is the 1787 convention, because they claim that the original Constitutional Convention was a runaway. It's just not true. That's just not true history. I wrote an article in the Harvard Journal of Law and Public Policy, the largest, most conservative law review in the country. It's called Defying Conventional Wisdom. It's available free on the internet. I prove absolutely that the states and the delegates stayed within their instructions, that they were told to render the federal Constitution adequate for the exigencies of the Union. Thank you, Mr. Chairman. I'd be glad to answer any questions.
Thank you again, Dr. Ferris, for your testimony for HJR2. Any questions from members of the committee? Representative Gross.
Thank you, Mr. Chair. I'm sorry, sir. This is your second testimony, right? I'm sorry. I had to step out and check into another committee. So multiple times among my colleagues, they state that they're actually just bringing up these bills to threaten Congress. They don't really want to go to an Article 5. It's just brandishing the Constitution to those of us who love it dearly and want to take a risk at destroying it. Do you not believe, sir, that as we go along as a nation and we look at our Constitution, we have state after state that says we want to change our Constitution, that our adversaries like China and others like Russia look at us and they say, look at the chaos in the United States, and that they don't look at that as a sign of weakness and look to influence, as we know China does in multiple other ways, influence our delegates, influence, because we know they are not state elected officials, they're appointees. What do you believe that our adversaries are not going to look at that as a sign of weakness as we look at the Constitution that undoubtedly saved us during COVID from joining some World Health Organization compact, it is our Constitution that saved us, sir. And so I'd like to know, do you not believe that our adversaries are looking at us trying to take and allow and to change the Constitution that was developed by God and in his sovereignty? I just don't understand how you would believe that our adversaries would not look at this as a sign of weakness and a sign of chaos in the United States of America.
Mr. Chairman, Representative Gross, I'm going to start with the World Health Organization. The reason I was in the process of discussing litigation, I was being hired by Republican senators. I was going to file a lawsuit challenging the constitutionality of the executive order that President Biden was planning to do to purportedly join the pandemic treaty. And the only reason he didn't join the pandemic treaty and issue it as an executive agreement, which is a little different than an executive order, is basically the president by himself joining into a treaty. The only reason he did is they couldn't get the treaty through Geneva. I was the president of Alliance Defending Freedom for several years. ADF has a team in Geneva working on defeating that effort to get the pandemic treaty through. It would be a terrible thing for pro-life. It would be a terrible thing on parental rights. It would be a terrible thing in sovereignty. It would be terrible all the way around. And the reason that was a threat is the very reason we need to do this. Because out of the 200 treaties, Representative Gross, there are 200 treaties that the United States enters into every year. 200. Out of that 200 treaties, two go to the United States Senate for ratification. That's the average, the rolling average for several years. Now, why is that? That's because the Supreme Court, in a case called United States versus Pink, and there's a few other related cases in the 40s, in the era of Franklin Roosevelt, said that executive agreements entered into by the president, even though they're treaties in international law, they can be constitutionally different. And we have a runaway treaty process in the country. You want to know how China can get to us? The way China can get to us is through these executive agreement treaties. And there's 198 of them coming down your throat every year. And there is no way that any of this, they're taking advantage of weakness. Weakness is when the executive branch, when one person alone can bind the United States to enter into a binding treaty with other countries. That is weakness. And they're taking advantage of that 198 times a year. Your ideas of how it might work, frankly, is conjecture and fanciful. What I'm talking about is real and happens 198 times a year. You want to stop this? You pass HJR 2 and we change the treaty provisions of the Constitution to make it absolutely explicit that there's no such things as executive agreements. We define treaties, which is there's an accepted international law definition of treaties, which is a written agreement between nations that binds nations by law. That's the accepted definition. It's not word for word, but very close. And we put that definition in the text of the Constitution, say anything that's that has to be ratified by 2/3 of the United States Senate. Now, that's how you stop China and others from taking advantage of us. That's real. The idea that China would no more be able to bribe under this bill anybody that gets over $200 from any source whatsoever is violating the law. So if China tries to bribe them, they got a limit of $199. I don't think that's going to buy many votes. They could just as easily bribe every state legislator in the country. They could just as easily bribe every member of Congress, every judge. We might as well give up on self-government entirely if you're going to say, well, China could bribe them. And if that's the idea, they can bribe everybody. It's like The Incredibles. If everybody can be bribed, nobody can be bribed. The Constitution was written by people who believe this. Every man's a sinner. Everybody's a sinner. And you don't give any sinner too much power. If you give any sinner too much power, you've got danger on your hand. And what I'm arguing for and what you appear to be opposing is the idea that the state senators should stop the federal senators from abusing the federal power. I contend that the senators that are in the state legislatures of all 50 states, just like all the voters are senators, everybody's a senator. But we, the voters, want to make sure that you have a constitutional duty. You took an oath to defend the Constitution of the United States. The Constitution, Article 5, gives you the authority to rein in the abuse of power of the federal government in only one way. And that's this resolution that's in front of you right now. And through that, you have the ability to rein in the abuse of power. If you don't do it that way, you have no other constitutional method. No other constitutional method. You can make something up outside the Constitution, but the only authority that's given to you in the Constitution of the United States is in the text of Article 5. And the question before you is, if God gave you that authority, are you going to use your authority in a morally responsible way and make sure the federal government stops abusing its power?
One follow-up, please.
I would argue, sir, that nullification is another path. I would also argue that an Article 5 is a ripcord to a fighter pilot, and there is a one-time use, and that plane goes down. You get it once, and you get to use it. But I also know, sir, that the people are the limiters, since we are talking about HJR 2. In the last 10 years, 315 congressmen have been replaced by the people of the United States of 435. Now, we can argue about those that are left, but I would say that, sir, that the replacement of 315 in 10 years, that would say to me that the Constitution is working, since the boundaries of this bill is term limits on HJR 2. It was using an Article 5 for term limits. Am I
You're
correct
wrong.
on that?
Sorry.
Am I not? Is that not what we're talking
Is that
about?
a
or-
question? Is that a question?
No, but I mean,
Okay.
am I correct on that? That's what HJR 2
The-
is, term limits, right?
The term limits one is Representative, yeah, it's HCR 3. It's Representative.
Oh,
Workman.
sorry. Okay, my
Yeah.
bad.
Yeah.
Scratch that. I thought it was HJR 2.
No,
Oh,
no
3.
worries at all.
I thought
Mr.
3 was
Chairman,
2.
may I,
We have
Since
another
term
one.
limits is part of this, may I respond, Mr. Chairman?
Yes, term limits is part of this, but this is a
Oh.
little bit more broad. In the bill analysis or the resolution analysis, talks about the second one, specifies that the convention is limited to proposing amendments that impose fiscal restraints on federal government, limit the power and jurisdiction of federal government, limit the terms of office for its officials and its members of Congress. We've heard HCR 3 as well, so it is a little confusing. So
I apologize.
No,
Chair.
apologies. No worries at all. Yes, Dr. Ferris.
Mr. Chairman, Representative Gross, there's far more that's need to be done than term limits is one of the topics that's germane. This legislature, of course, is free to vote for both. There's no reason you shouldn't vote if you support them substantively. If you support the idea of term limits on federal congressmen, you can vote for HJR 3, and it does no damage to HJR 2 one way or the other. If you like the idea of term limits on all federal officials, including the possibility of federal judges, including the possibility of federal officials like Dr. Fauci, then our language for term limits is broader than the language in HJR 3. But the idea that we are doing something violent to the Constitution and that 315 members of Congress, if that's the correct number, over 300 members of Congress have been replaced over the number of years that you stated. That's an interesting and an important argument about term limits. The number I would give you back is 39 trillion. $39 trillion. I had a bumper sticker on my file cabinet when I was first a lawyer. It said, "No $1 trillion debt." We're now at 39 trillion of the amount that we count. If we did regular accounting principles, the amount that we've stolen from the Social Security Trust Fund and so on, it's north of 150 trillion is the real national debt. And so that's the number to me that no matter which the members of Congress are, we have to do something structural to stop the runaway spending, stop the runaway debt, and do something to bring the federal government under its responsibility. Thank you, Mr. Chairman.
Representative, let's go Vice Chair Ferguson first.
Thank you, Chairman. Thank you for coming in for your testimony. This one, I might have differences with my colleagues on the Republican side, sometimes those with the Democrats. And that's why the premise of this question, I just ask, we have turnover here in this legislature. And so what's asked in a lot of these calls of conventions is that we just broadly say whenever a convention is going to be called, Ohio will be there. But, I have term limits, and Rep. Gross, for instance, I don't really feel comfortable necessarily saying that the next legislature and the one after that and the one after that and the one after that should all be going to a convention. So the question being, would you be supportive of us doing this on more of a rolling basis, meaning like every 2 years, we would have to re-up the call for the convention because what the topic might be might vary, who's elected in this legislature might vary, and that's really, I'll leave it open-ended to you.
Okay. Mr. Chairman, Representative Ferguson, thank you so much for the opportunity to clarify. There's a bit of the first bill and there's a bit of the second measure in your question, if I can address them both a little bit. A delegate appointment bill, HR 67, gives you a process for whenever you're going to have a particular convention, and that's essentially timeless. There's no reason. You're going to want to appoint delegates. You're going to want to give them instructions. You're going to want to say how they're appointed and who they report to and things like that. That's, it's non-controversial from my perspective. It's just straightforward stuff, and you can give them additional delegates or instructions rather when it comes to a particular convention. An application, HJR2 is an application. You can time limit it if you want to. A few states have, both states that I'm recalling, Oklahoma and Texas. Oklahoma did, they had it for 5 years originally, and then they rescinded that later. Texas had 5 years, and they're in the process of rescinding it right now, and I don't know what the status is. I know that's going on in this legislative session this year. And so it's been done. Okay, thank you. So but applications last as long, but they're only per that topic. And so Ohio has passed applications in the past, and those are good until one of two things happens, or three things. One is you rescind it. You can rescind any application at any point in time. When you do, it's gone, or at least Ohio's participation of that is gone. You can, you can't, or if there's a convention held on it, then okay, it's been used up. If you put a time limit on it and that time limit passes. So the basic rule is whatever you say about how this works for Ohio, that controls. So if you want to put a time limit on HJR2, I would ask you not to put 2 years because the process of this getting done just takes longer than that. But if you wanted to put a process on it, I would suggest 10. And so the states that did 5 found that to be too short of a time. But I like the idea of things being roughly contemporaneous. And I think that 10 years would be a good amount of time. So if you want to make sure that this topic is limited to, if you don't bring it up in the next 10 years, then you got to start over. It wouldn't be my favorite, but I wouldn't have really any objection to that. Is that responsive to what you're asking? Okay.
Thank you, Vice Chair. Representative Rader.
Thank you. This is actually be kind of a follow-up to Representative Ferguson, and thank you again for sticking around. So Ohio has passed this, like you said, the resolution a couple of times. I think the first time was in 1861, quite a while ago, for a general convention.
Right.
I guess my question is, why wouldn't those currently still stand or apply? Sometimes when people are counting how many states have passed this, they already include Ohio as passing it because the last time we passed it was in 2013 for a budget, for a balanced budget, right? Which is similar to kind of what we're talking about here today. So if we were to pass it again, or we're just to be added to the pot, why wouldn't we already automatically be calling for a general convention where any topic can be discussed and deliberated on?
Mr. Chairman, Representative Rader, the Ohio's 1861 resolution, if you have not repealed it, and I don't think you have, it's still in place and is valid. And it would aggregate, if 34 states called for a general convention, it would aggregate with those. It will not aggregate with those that have called for child labor amendment or right to life amendments or redo one man, one vote amendments. It aggregates only with other amendments on the same topic. And there have been approximately 14 general applications in the history of our country, never 34, and most of those have been subsequently repealed. I don't have an exact count, but I think it's about 5 that are extant right this moment. But they only aggregate with others of like kind. And so your balanced budget application is still valid, and it aggregates with other balanced budget applications, provided that they're not too particular. For example, Mississippi's application says they want to have a balanced budget, a convention for a balanced budget amendment, and they provided an exact text and say, we call a convention only for this text. It aggregates with nothing else but itself. Mississippi's going to have to do it over again if they're going to want to join a general call for a balanced budget amendment. So when like joins like, if you think of it basically like the process of a House passes a bill and the Senate passes a bill that's similar, that's not law. You got to agree on the exact text. And when there's an agreement on the exact text, when there's an agreement on the topic, then you've got a convention. There's no agreement on the topic, you don't have a convention.
Got it. And thank you. I think I just want to clarify, I misspoke. 34 is the number you need. I think 28 states have passed some version of this up to this point, is I think what I've read. On different topics calling for some type of Article 5 convention. Is that right? I don't know.
Mr. Chairman, Representative Rader, 49 states have called for a convention on something. And that's, but there's never been 34, 2/3 of the several states on a single topic.
That's helpful. Thank you, Mr. Chair.
Any other questions? Seeing none, thank you so much, Dr. Ferris, for your testimony on both of those items. Next, we'll call up William Scott for testimony. Welcome to committee. You can begin when ready.
Chair Hall, Vice Chair Ferguson, Ranking Member Humphrey, members of the committee, my name is Bill Scott, and I live in Dayton, House District 36. I'm going to streamline my comments in the interest of time because I know I would go more than 5 minutes, but I'll do my best. I start with a brief overview of what a convention of states is and what it is not. When the states gather for the first time under the authority of Article 5 as duty-bound agents of the states, it will be for the sole task of proposing amendments to the Constitution. This is very different than the purpose of the Constitutional Convention that organized our founding in 1787. The scope of that original 1787 convention was necessarily broad due to the many structural problems with the Articles of Confederation. Conversely, what's being proposed here in HJR 2 is a meeting of 50 state legislators, delegates rather, to debate and propose amendments in 3 limited topic areas under the authority of Clause 2 of Article 5. A limited amendment convention is not a constitutional convention. These are 2 very different things, and conflating these 2 things together is really a misnomer. They're 2 different animals. So, I'm not going to list them again. It's in my testimony of what the 3 areas are. You've heard them about fiscal restraints, limiting power and scope of jurisdiction, and limiting office terms for the Congress and federal officials, which Dr. Ferris mentioned. How about any more Dr. Fauci's out there? I don't think we need those kind of folks with those 50-year careers in Washington. So why does COS advocate for 3 topic areas? I think we've touched on this a little bit. But why are we going to have 3 topics versus just 1? Well, imagine this. You're a homeowner with a major water leak, so you call a plumber to fix a serious leak issue. Does that plumber arrive at the job with just a pipe wrench? No. He'd also bring a toolbox filled with a variety of essential tools he needs to fix the water leak. Similarly, our federal government faces a structural problem in how it conducts its business and makes decisions. In medical terms, the federal government is in critical condition, and calling an Article 5 convention to focus on just 1 topic will not save a patient that is on life support. The government's structural problems without having the flexibility to debate multiple proposals just won't work. So the 3 topic areas listed in HJR 2 provide those tools that the delegates really need to be effective in their jobs. I mentioned a moment ago that the federal patient is on life support. And unfortunately, that's not really hyperbole. You guys all remember what happened this past Friday with Moody's downgrading the AAA rating for the first time ever in the history of the country. That happened on Friday. We no longer have a AAA credit rating for the United States government. They are now a AA1, first time ever. You couple this Moody's downgrade with what's happening globally to degrade the confidence in the American dollar, and it's obvious to U.S. citizens already concerned with the size of the federal debt that something has to change. Some sweeping changes are needed in Washington. In less than 2 months, the BRICS nations are meeting in Rio de Janeiro. These BRIC nations are understandably looking for alternatives to the U.S. dollar for world trade and as a reserve currency. It's time for we the people, through our state legislatures, you, to stage an intervention. A convention of states is a great opportunity to restore confidence that America can responsibly manage its fiscal house and return to constitutional self-governance. The delegates will decide the specific topics, but I just want to mention one or two in the fiscal area since that is my background. How about an amendment with a balanced budget with limits on taxation? Congress could be required to submit a budget to the president by a specified date, say the first Monday in May. Unless a budget is signed into law by that day, and across the board reduction in expenditures could be mandatory. How about, this is one of my favorites, one subject, one bill. Limiting each congressional bill to a single topic would reduce spending immediately, as legislators could no longer bury special favors and pork spending in these multi-thousand page incomprehensible omnibus bills. That's really a sin to do that. It has to stop. We would allow voters to hold their legislators accountable with a single subject bill. It really is very important, I think. And I hope they tackle it at the convention. There are just a couple of examples of amendments. Of course, the delegates will make their own decisions on which of those 3 topic areas they will write proposed amendments. So in closing, I'd ask you to please support HJR 2 in helping to bring permanent fiscal responsibility to our federal government. Our country must have a stable and prosperous financial future, and for generations now and for generations to come. So don't let irrational fears promoted by naysayers sway you from doing the right thing. As Edward R. Murrow once said, we are not descended from fearful men. Thank you for letting me testify.
Thank you, Mr. Scott. I know that we're looking at the clock like I was able to get the next committee to be moved to a different meeting room. I did not want to shortchange any voices that have come to Columbus today to voice their support for this. And then we have one more proposal after this to be heard before the committee. So do not worry about the 4:10 deadline anymore. Bree Austin, our phenomenal policy advisor, has worked out a deal to move the next general government committee to a different room.
We very much appreciate that. And
Yes.
the rest of our testifiers here were practicing speed talking.
Yes.
I don't think you want to hear that.
You see me texting up here. That's what we're trying to work a deal to move it to a different room. So Representative Gross has a question for you, Mr. Scott.
Yes.
Thank you, Mr. Chair. Thank you, Mr. Scott. In reference to your testimony, number 1, imposing fiscal restraint on the federal government. Your legislature, sir, has indebted ourselves 35% of our, depending on who you ask, $210 billion. When we draw down money from Medicaid, when we draw down money for the hospital franchise fee, sir, when we spend every dollar, the federal government matches us. So how would you spank, if you will, with an Article 5 convention, the federal government, when your very own legislature, not yours, your own legislators are voting to take more money from the federal government, which then bloats the federal government. And then we are to go back and smack the federal government and say, bad federal government, you need to be fiscally restrained. But your Ohio legislature is not. How do you justify 35% of our operating budget coming from the federal government as the 7th largest state in the union. How do you answer that? How do we go back and say, well, you know, it wasn't really us that took the money. You're the problem.
To the chair, Rep. Gross, I think that is a common problem. It's called the trickle down, and it's called the handcuffs that the federal government's put on you, and it's even worse than that. It's even worse than that. That's in Medicaid. Medicaid, the Obama expansion, the Obamacare expansion, the incentives are even greater for people on the expanded care. So it's something that you have to change the mindset when you're resetting how the government funds itself and whatnot. You know, block grants can be done, put the money back in the state, and don't let the federal government hold those handcuffs over you like they do now. And that's a whole different paradigm of how things have to change. So I agree with you. Those are problems with every state, not just Ohio. And this kind of a fiscal amendment could perhaps change that paradigm. And it would. I'm pretty sure it would be high on the agenda on how we fund the states and the mandates that come.
But to follow up with you, sir, we didn't have to expand. Your legislature chose to. The governor at the time chose to expand Medicaid. It required state law and state legislators to choose to expand how much money we take from the federal government, by and large shackling ourselves, just to clarify.
I agree with you that it is a problem.
Thank you,
But I
sir.
think we need a paradigm shift in Washington, and an Article 5 convention can do that.
Any other questions from members of the committee? Seeing none, thank you so much for coming in and for your testimony today. We have next Diana Tellis. If she wants to, we weren't sure if it was written or in person, but.
In person.
Okay.
And I've written it here, but I've crossed a lot of it out so I don't repeat.
Perfect.
Dr. Ferris?
And just so you guys all know, in the audience, members are walking in and out. There's other committee meetings going on. There's other meetings going on. So I promise you, your voices, they're not leaving because they don't like you. They're not leaving because they don't like what you have to say. They're leaving because they have other things. Go check in, come back. And all of this is obviously live streamed on the Ohio channel, so we can all go back and watch that at a later date. So Ms. Tellis, you can begin when ready.
Chair Hall, Vice Chair Ferguson, Ranking Member Humphrey, and members of the committee. My name is Diana Tellis. I live in Westchester, House District 45. Happy to see Rep. Gross here today. And excellent questions today. We appreciate it. And thank you for the extra time today to get this testimony done. I've crossed out a lot of my testimony here because Dr. Ferris covered a lot of the spoiled child, we are the parents part of my testimony. I would like, if I could, make it clear that there has never been a rescission of our resolution, our specific, no rescission at all. Maybe other ones, some of them from like, I thought the state of New York may have been rescinding some from like the 1800s or something, but certainly not ours. So those who would, I am cutting down here, I'm doing the best I can. So those who would say that, no, this is all too dangerous to do this. The states cannot be trusted to propose and ratify amendments to the Constitution. There could be a runaway. We would reply, how absurd. The states wrote and ratified the Constitution. We are the parents. The facts bear out that the real danger lies in the spoiled behavior of the federal government. And yes, this federal government has drawn the states into that, Rep. Gross. It's landed our country in grave danger with $36 trillion debt. Something must be done. And since when do Americans reject corrective action based on hyperbolic messaging? We do not avoid driving cars because someone insists that it's too dangerous. We take medication, we face surgeries to address health issues, largely expecting a positive outcome, not cowering over doomsday prediction. Level-headed people do not live their lives in paralyzing fear. The real danger rests with state legislatures who refuse to step up and behave like parents and discipline the federal government. Individuals who oppose an Article 5 convention are under the impression that the Constitution of the federal government that it follows is simply the original Constitution with 27 amendments, a document small enough to be tucked away in a briefcase. That is entirely false because the federal government follows an annotated Constitution, which is the Constitution as interpreted by the Supreme Court. This is the book that is over 2,600 pages in length. You see, every time the Supreme Court rules on federal constitutionality of a case, it is added to this Constitution. It literally gets thicker every year. It's literally amended every year by the Supreme Court. The Supreme Court has effectively amended the Constitution for virtually every year since the ratification of the Constitution. Given the abysmal performance of our federal government, I would say it's about time that we, the states, step up and have our voices heard. If you're unhappy that federalism is essentially dead and you want to curb the ever-growing power of the federal government, then it's time for Ohio to add its name to the list of states requesting for an Article 5 convention. Let's rein in that teenager. I invite you to consider our beautiful American flag, the most American symbol there is. It evokes a feeling of national pride. Yeah, sorry. The American flag represents our country and our core values. Red denotes valor and bravery, white, purity and innocence, blue, vigilance, perseverance, and justice. Look at the other symbols. There are 13 red and white stripes, which represent the original 13 states that created the federal government. The stripes represent the very origin of our country. These 13 states expressly reserved the authority to rein in the federal government via amendment. There are 50 white stars on a dark blue background that represent the 50 states that we are today. I submit that to deny these states, their sacred constitutional right to exercise their authority under Article 5 of the Constitution is actually anti-constitutional and anti-American. History is on our side. The facts are on our side. The Constitution is on our side. Common sense is on our side. We now invite all of you in this committee to be on our side and vote in favor of HJR 2. A vote in support of our legislation honors the founders. Thank you for listening.
Thank you for your testimony today. Representative Gross has a question for you.
Thank you, Chair. Thank you, Mrs. Tellis, for being here. Since the Congress does not accept or follow the Constitution as written, why do you believe that when we redo a Constitution through the nuclear option of an Article 5 convention, why do you believe that Congress will then all of a sudden obey the Constitution?
Well, historically speaking, we do follow amendments when they are passed. What amendment are we not following right now, Rep. Gross? Through the chair to Rep. Gross.
You feel free to answer if you'd like to answer.
Yeah, I would like to answer.
I'm not going to answer that right now.
Oh, okay. It was rhetorical. It was a rhetorical question. Furthermore, the Commerce and General Welfare clauses, Dr. Ferris didn't address that, but one of the things we would like to see is a cleanup of that language, because what they are is they're following the Constitution. They're following the annotated Constitution. That's what's happening. The General Welfare Clause would have never allowed the kind of spending in Washington, D.C. that you're seeing today. We would never be in this situation if they followed the limited spending that the federal government is supposed to be following, but they're not. And the General Welfare Clause was reinterpreted by the Supreme Court. It's all in here, and they are following this Constitution. That's why we're spending on things that the federal government should never be spending on. It should have been, defense, very, very little else, trade, diplomacy, and nothing like what we're seeing today, nothing like we're seeing today. That's why we're $36 trillion in debt.
Representative Gross, you have a follow-up?
Just that you answered your own question. They're not following the Constitution as written.
No, they are following the Constitution.
Not the original
This
Constitution as
Right,
written.
but this is the one they're following.
It's
This is
not
the one they're following.
Constitution.
It's the annotated Constitution as reinterpreted.
Thank you. Thank you for that discussion. Is there any other questions, members of the committee? Seeing none, thank you for your testimony today. Next, we're going to call up Ed Mulholland for his testimony. Welcome to committee. You may begin when ready.
Thank you, Chair Hall, Chair Ferguson, or Vice Chair Ferguson, members of the committee. My name's Ed Mulholland. I'm from Zanesville, Ohio, House District 97. The Declaration of Independence was an announcement to the world that the colonists could and would manage their own affairs. It was a statement establishing the right of liberty and local sovereignty. The Constitution followed securing the liberty of the people by granting the federal government only 27 enumerated powers. James Madison, author of the Constitution and fourth president of the United States, said it this way: "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which remain in the state governments are numerous and indefinite. This division of power is called federalism, and it's critically important. We know the federal government is too big and powerful. By 2019, there were already over 1 million regulatory restrictions placed on us by the federal government. This expansion of power was never intended by the founders. For that, we can thank a series of Supreme Court decisions that have interpreted the Constitution in ways unimaginable to the founders. The General Welfare Clause was never meant to give government unlimited power to pass laws or spend money on whatever it deemed beneficial. Likewise, the Commerce Clause was never intended to give the federal government power over local economic activity. Unfortunately, decisions like US v. Butler in 36, Wickard v. Filburn in 42, reinterpreted those clauses, giving virtually unlimited power to the federal government. I'll take a little aside, adding pages to the Constitution that gave them that extra power. HJR 2 empowers states to propose amendments that would limit the power and jurisdiction of the federal government. States, through their chosen delegates, could propose amendments to reclaim federalism. Perhaps an amendment that would clarify the meaning of the Commerce Clause, restoring states' rights and allowing for more diverse and local solutions rather than the one-size-fits-all regulations coming out of our federal government. Perhaps an amendment addressing the exponential growth of federal regulations, something as simple as requiring Congress to approve by a majority vote any regulation deemed to have a significant financial impact, say $1 million or whatever. We have had several presidents threaten to stack the Supreme Court, a hostile takeover of one branch of government by another. This kind of attempted power grab could be prevented with an amendment limiting the Supreme Court to just 9 justices. Over the past few years, we've witnessed absurd levels of waste, fraud, and inefficiency of the federal government. The IRS spends about $3.5 billion per year on 8,000 IT employees to accomplish what a mid-sized bank with 200 employees could do on a budget of $200 million. Think about that. Only the government could spend $3.5 billion a year on IT and still be using a computer system from the 1990s. How about $312 million in loans that were granted by the federal government to children age 11 or younger during the COVID pandemic? Those are just 2 examples, $1 billion here, $1 million there. Sooner or later, it becomes real money. Imagine an amendment to the Constitution that requires federal agencies and departments to undergo an independent financial and operational audit on an annual basis with mandatory public sharing of results to ensure transparency and accountability. Oh, something I had to do every year as a director of a local nonprofit. Every corporation has to go through that. These are just examples of potential amendments that could be considered at an Article 5 convention. I'm sure you can imagine many more. HJR 2 gives states the opportunity to at least discuss these important issues. In 2013, Ohio passed, with bipartisan support, a resolution calling for an Article 5 convention to discuss a balanced budget. You have another proposal calling for an Article 5 convention to discuss term limits. HJR 2 includes both of these topics and the critical third leg of the stool, limiting the power and jurisdiction of the federal government. All 3 are necessary to restore federalism. Alexander Hamilton, who helped write the Constitution, wrote in Federalist 85, "By the 5th article of the plan, we may safely rely on the disposition of the state legislatures to erect barriers against the encroachment of the national authority." Ronald Reagan and other great Americans said this regarding Article 5. "The Constitution provides for both methods, and the convention is a safety valve, giving the people a chance to act if Congress refuses." Representatives, Congress has refused to act, and it's time for states to take action. The people are asking you to do it. I urge you to support HJR 2. I'd be happy to take any questions.
Thank you. Thank you for your testimony. Right on the 5-minute dot. I don't know if you can see that up on your screen, but you were right on time. Appreciate that. Any questions from members of the committee? Seeing none, thank you for your testimony today.
Thank you.
Next, we'll call up Roger Gibb for proponent testimony. Thank you for coming today. Begin when ready.
Chair Hall, Vice Chair Ferguson, Ranking Member Humphrey, and members of the committee. My name is Roger Gibb, and I live in Mason, Ohio, House District 56. The testimonies you've heard today all are in support of HGR2. In a future hearing, you will receive testimony from those who oppose state legislatures requesting an Article 5 Convention of States to propose amendments to the Constitution. In the upcoming opposition testimony hearing, you should expect to hear provocative fear-mongering claims that include the following. Well, delegates to an Article 5 convention will have plenipotentiary or unlimited power, and they could use it to eliminate the Bill of Rights. An Article 5 convention could run away and write a new constitution. None of these claims are tethered in reality. Now, to put this in perspective, let's just imagine that you go skydiving with a friend. After free falling for a couple of minutes, you both decide to deploy your parachute. So you reach back, you pull that parachute strap, nothing happens. Initially, you panic, but then you remember you've got a second parachute in your backpack in case the first chute fails. So you reach back to deploy that second parachute, but your friend calls out, "No, don't do it. That's too dangerous." Confused, you look down at the ground. It's coming up pretty quick. You look back at your friend and you say, "More dangerous than face planting at 90 miles an hour?" The second chute's there in case the first chute fails. Do you have a better idea? Your friend looks back and says, "Well, no, but trust me, don't deploy that second parachute. It's too dangerous." Now, as absurd as that sounds, that is effectively what our opposition is saying. You see, we, the American people, we are like the skydivers, and we're faced with a very dangerous situation. Our federal government is literally bankrupting our country with debt, among other things. If Congress is the first parachute, and if Congress were doing its job, it would propose reasonable amendments, like a balanced budget amendment, to address this issue. Congress refuses because Congress is part of the problem. Our second parachute is for the states to propose amendments to the Constitution. This provision is packed right into Article 5 of the Constitution to be used in case of an emergency like this one. Yet our opponents claim that's too dangerous. Do they have a viable alternative? No, but they're intent on stopping us from deploying our proverbial second parachute to save our country. Those who support HGR2 rely on a team of nationally acclaimed attorneys to research and confirm the safety of the Article 5 convention process. Two members of that team include constitutional attorneys Michael Ferris, whom we've heard from today, and Robert Nadelson. I won't say anything more about Professor Nadelson, or rather Michael Ferris, because I think we all witnessed his expertise and knowledge on the subject. I will tell you a little bit about Robert Nadelson. He's a law professor of 25 years, and his research has been cited repeatedly at the US Supreme Court, federal appeals courts, and state Supreme Courts. He's widely acknowledged to be the nation's preeminent scholar on the Article 5 convention process, having written the only legal treatise on the subject. He has also written more than 40 articles on the Constitution in law journals. So Michael Ferris and Professor Nadelson have collectively written more than 300 pages in law journal articles to specifically refute the claims that the Article 5 convention process is somehow dangerous. The claim by George Soros organizations and the John Birch Society that an Article 5 convention of states would be dangerous has been thoroughly debunked by Michael Ferris and Professor Nadelson. If anyone on this committee has reservations about the safety of an Article 5 Convention of States process, then I urge you to take some time and read the articles of Michael Ferris and Robert Nadelson. If you do that, you will find that their writings are based on a solid foundation of history and fact, not rumor and not superstition. And so in closing, I would like to ask a rhetorical question for each member of this committee to consider. If you or a loved one were in serious trouble and required legal counsel in the highest court, whose counsel would you trust to save you? Our nationally acclaimed team of veteran constitutional attorneys, or our opponents who are little more than history hobbyists? If you wouldn't trust our opposition's advice to save you or a loved one, then why would you trust their advice to save our nation? Thank you for your attention and for your service to Ohio. I urge you to support HJR 2. Thank you.
Thank you for being right on the 5-minute time. Any questions from members? Seeing none, thank you for your testimony today. Last in-person testimony we have on our agenda is Susan Dunn. Is Susan with us? There's Susan. Susan, welcome to committee. You may begin whenever you are ready.
Chairman Hall, Vice Chair Ferguson, Ranking Member Humphrey, and members of the committee, my name is Susan Dunn. I live in Westchester, Ohio, House District 45. Through the chair to Representative Gross, may I?
Do you want to do your testimony first and then we can come?
No, I just wanted to tell Representative Gross it's good to see you, and I'm thankful and encouraged that this committee gives everyone here the opportunity to truly understand HJR2 and the citizens who believe in it. Thank you. I present 5 clues that those who are opposed to HJR2 are on the wrong side of history. Clue number 1, their position on HJR2 suggests they are of like mind with George Soros. Soros is a fan of big progressive government and is proficient when it comes to smearing Article 5 of the Constitution. Check out the commoncause.org website and search Constitution Article 5. You'll find articles spouting the same arguments about the dangers for states to exercise their authority to rein in the big government that Soros loves so much. Moreover, those repeating claims like an Article 5 convention will run away shouldn't be surprised when suspected of being in Soros' camp, because that's exactly what Soros and his fellow travelers say about Convention of States and HJR2. A definite clue they're on the wrong side of history. Clue number 2, they think they can trust the feds more than they can trust state legislatures. The feds, including Congress, are responsible for our over $36 trillion debt. Every week, there's a new revelation by the Department of Government Efficiency of how a federal department or agency has wasted billions of tax dollars. Can Congress be trusted with fiscal responsibility? Now, the majority of state governments, including Ohio, although far from perfect, have constitutional amendments or statutes that require a balanced budget, which is a big step in being more fiscally responsible. Those trusting the U.S. Congress to propose amendments to the Constitution more than trusting state legislatures are likely on the wrong side of history. Clue number 3, our opponents complain the federal government fails to follow the Constitution, yet claim we should not follow Article 5 of the Constitution. It's hypocritical that passionate opponents of HJR2 claim great love for our divinely inspired Constitution. Yet, when Article 5 is presented as a way for states to rein in the federal government, they oppose following that part of the Constitution. Their hypocrisy is a clue they're on the wrong side of history. Clue number 4, they revere the framers of our Constitution but think they wrote it dishonorably. An oft-repeated myth by our opponents is the idea that our Constitution's framers were not authorized to write it in the first place. They claim George Washington, the man with impeccable integrity, and dozens of other trusted stalwarts of the Revolution went rogue and drafted the Constitution against the wishes of their superiors. Never mind today's constitutional scholars, Michael Ferris and Robert Nadelson have thoroughly debunked these outrageous ideas in peer-reviewed law journal articles. George Soros and the John Birch Society just keep repeating them. Another clue, they're on the wrong side of history. Clue number 5, they think they are courageous and patriotic Yet their actions show they believe in fear and the status quo. When George Washington crossed the Delaware with a ragtag shoeless army at night on Christmas in a blizzard to fight the Hessian mercenaries in Trenton, he and his men exhibited incredible courage. We honor them because they rose to the occasion, not succumbing to fear. Our opponents believe we should fear using the Constitution to save the Constitution. Again, this puts them on the wrong side of history. Following the Constitution, including Article 5, is not something to fear. Rather, it's a privilege and honor to have and exercise that constitutional authority. You have that authority, and through HJR 2, you can exercise it. Please place yourselves on the right side of history, exercise courage and your authority to rein in our runaway federal government, and support HJR 2. It's what the framers of our Constitution would do if they were in your position today. Thank you for your attention and for your service to Ohio.
Thank you for your testimony today. Representative Gross has a question.
Thank you, Chair. I really appreciate it. Thank you for being here for your testimony today.
You're welcome.
At the original convention, Constitutional Convention, a majority of delegates voted to close the convention and keep it secret. What would prevent the delegates in this convention from doing the same?
Not being there, I do not have an answer for you. I would like to have time to research that and get back
Yeah.
with you.
If you could do that, and then if you find an answer, or there's an answer in the audience, you can
Follow up?
gladly submit it to our office, and then we will disperse it to members of the committee as well.
Follow up?
Yeah.
I would do that.
So let me ask another question. So what would happen if we had a convention and half or a few of the states walked out? Would the convention still be valid at that point?
Again, I will get back to you
Yeah.
for certain because
Absolutely.
Okay, thank
these are
you.
little details.
Thank you.
Thank you, Representative Gross. Vice Chair Ferguson has a question for you.
So of course we get a lot of these. I think we talked about earlier, we have another one for US term limits that's been asked to us. But of course, we're trying to get the state legislators to act. I just want to know if you've had interactions with federal legislators about taking action. Of course, we know they don't like to do much there, but I just want to know what response you might have gotten from our congressmen here in Ohio or US senators to kind of take action the congressional route.
Are you speaking of like endorsers of convention? of
No, I
states?
mean for them to take their own action at the congressional level, the federal route versus going this way. Have you, or really anybody anecdotally, I mean, why are they relying on us to do the work and to get it done? I mean, we're glad to do the work if it makes sense, but why, I mean, they answer to you, the voters. Why are they not taking action when clearly there needs to be action?
Chair Hall, please through Chair Hall to Representative Ferguson. That's why we need to call a convention, because we have endorsers at the federal level. We have, as a matter of fact, J.D. Vance is a supporter of Convention of States, Marco Rubio, Caroline Levitt, and many others. In my personal talking with Representative Davidson, he listens. He always listens. I've also talked, of course, to his staff in the local office. I know that there have been folks up in northwestern Ohio that have been in contact with Representative Jim Jordan. They listen. But they haven't ever said, well, why don't you just let us handle it? And to that, I would say is why we need to do this. If we could get a convention called, then we believe they'd be on their toes. And they might even do what was attempted when Ronald Reagan was working on the balanced budget amendment. And he had, I think, like 33 states. Am I right? I believe that's correct. And all of a sudden, Congress, they jumped to and they said, hey, we're going to take care of this. Never mind. We're going to take care of this. You know what happened? They never took care of anything. But the convention idea just kind of faded away. So we, the people, with the support of our state legislatures, need to take the ball and run with this.
Any other questions from members of the committee? Seeing none, thank you so much for your testimony today.
Thank you for your.
That will conclude the last in-person testimony. Now, rest assured, members, we have, I believe my aide said we have over 80 written submissions for support for this HJR2. So please review those today, tonight, whatever works for your guys' schedule. Just want to say thank you for all of you for coming in today for this hearing. I know that it can be long days over at the Capitol, but this is the process of coming to your state capitol and testifying in front of state reps from all across the state. And I just want to say, really appreciated the discussion. Really appreciated you guys coming in today to testify for HJR2 and for House Bill 67 as well. So that will conclude the second hearing of HJR number 2. Last thing on our agenda will be super.
Sorry about that. I guess I've been muted. So welcome back. You've been watching a hearing on the Ohio House Government Oversight Committee on the COS Action Resolution under Article 5. That resolution is titled HJR2. And there was also HB 67, which is the 34 Ready Bill. HJR2 came after HB 67. Michael Ferris was there to offer testimony for both, and Michael Ferris was absolutely on fire. It was incredible. You also saw there was activists who were in the committee room. Several of them came up to testify in favor or in support of HJR2 and HB 67. Some noteworthy people who were there: Steve Jones, Diana Tellis, very passionate testimony. Bill Scott as well. Susan Dunn, she was the last person to speak. And there were several others that just had incredible testimony. There seemed to be one or two representatives who were very against HJR2. Representative Gross seemed to grill Michael Ferris and others to try and get them to, I guess, see the potential danger in an amending convention. Obviously, Michael Ferris was right there, ready to completely debunk any of the myths that she was peddling. So we're going to go real quick. We're going to go over to Catherine Zamanek. She's the regional director for Ohio. She's going to be offering some perspective on what she saw her team do today. Catherine, I don't have you up yet. All right. Looks like we're waiting on Catherine to get her video sorted out. A couple of things that I will mention while we wait for Catherine to get back up. I got to give kudos to Steve Jones, to Bill Scott, and several others, because there was many questions that were lobbied against them, that were lobbed at them, that were really gotcha questions. And all of them responded so well. They didn't allow these questions to cause them to cave under pressure. And they were able to reframe the question, answer it if they could. If not, Susan Dunn, for example, said, I'm not sure, but I will find out and I'll get back to you. And I just love how she was able to handle that level of pressure so well. It was really good to see our activists out there, unafraid and taking all of these questions that are not easy to answer. So it was really amazing to see that. Producer G, do we have Catherine back? Is her video up? All right. we're still waiting for Catherine to come up. One thing I did also notice is that Michael Ferris, he was on fire today. He really was at the top of his game. Every single question that was calling into question how dangerous or not dangerous this would be to have a convention of states, every single one he just came back with. I am one of the premier scholars on Article 5. I have written many treatises, and we have been able to prove that the convention in 1787 did not run away, but the commissioners, they operated inside their commissions. And he also talked about the WHO, and he talked about how there are treaties between the United States and foreign entities that get passed every single year, hundreds of them, and those are a danger to the United States. Instead of what Representative Gross was saying, where a convention would be a danger to the United States. So very interesting that was what she kept bringing up about the danger of a Article 5 convention. Michael Ferris was able to quickly disable her arguments very, very quickly. So I'm still waiting on Catherine Zemanek. Producer G, is she ready to come up? All right. Looks like we don't have Catherine Zemanek, but we'll give it another minute. So this was proponent testimony. Next, we're going to be going to opponent testimony. That's going to be happening in the near future. So like Rita said at the beginning, Ohio does things a little unique. We go from sponsor testimony to proponent testimony, then to opponent testimony. So you'll have to come back again and listen to some of the other. Oh, here we go. We have Catherine Zemanek. Glad you got your tech issues sorted out. Catherine,
can you hear me?
Yeah, I can hear you.
Okay, great.
Catherine, give us your initial reaction to what you saw in that committee room.
I'm always so proud of this Ohio team. They worked so hard. They prepared, and they stood shoulder to shoulder today with Michael Ferris. I thought Mike was just absolutely on fire, like you said. There are a couple of things that stuck out for me. You mentioned some of the people who presented. Roger Gibb gave the analogy of the parachute. I love that story about the parachute. It really hits home. Of course, Diana Tellis, whose rep is Representative Jen Gross, who asked probably the most questions today. Diana has prepared her testimony to answer many of the questions that Rep. Gross had. And so I'm so proud of the work that Diana and both Susan Dunn did. They both live in her district. And, they weren't rattled. They took on her questions, and they also hit them out of the park, I thought. So I'm very, very proud of their work. What can you say? I think she was all about making this about her side. And it was evident that other committee members were very attentive, listening, asked some good questions. So really, really proud of this team today. I expect that it will pass out of this committee.
Mm-hmm. Yeah, I noticed that too, and I had commented on that earlier, that they weren't rattled. I like how you said that. They really didn't cave under the pressure at all. And they did the best they could to answer the questions that were directed at them. And it seemed like Representative Gross was trying to do more gotcha questions. She wasn't interested in actually getting the answers that she wanted. She just was trying to do gotcha questions. That's what it seemed like, from my opinion. So tell me, what was the behind the scenes strategy that you and the team had going into this hearing?
Well, one behind the scenes thing that happened that people didn't hear about today was 77 Ohio supporters of Convention of States submitted written testimony today. So that's a great number. The committee members will have the opportunity to, if they choose to do so, to look at that testimony. The team always respects the time of the committee members. So that's why it was decided that they would just have 5 people testify today. We expect that when we have the opponent testimony, that the chair of the committee will stick to that they'll ask just 5 people. do testimony in opposition. Whoever their expert is that they'll bring in, it's certainly no one that can measure up to what Dr. Ferris did today. So I think they did outstanding, and there's no better team when it comes to testimony than this Ohio team.
Mm-hmm. So today was proponent testimony. Do we know when we might get opponent testimony? Is that coming up soon, or is there any idea of when that will happen?
It's pretty complicated for these committees. They have to look at their calendars and get that situated, because to have all the committee members there for a hearing, you have to remember that they're on other committees. So it's not easy to just say, pick a date and say, next week we're going to do opponent testimony. So they'll look at the complicated schedule that they have, and they'll pick the right day for the opponent. We're hoping that it is soon, and after that we can get a floor vote. And we also believe that we'll hear opponent testimony in the Senate committee soon.
So between now and opponent testimony, what is the team going to be up to? What happens next for the team?
We have a great crew that visits the Capitol once a month, and they talk to legislators. They had a tremendous number of new legislators in Ohio this year. They're what we refer to them as freshman legislators. So they had to get them up to speed. They're still working on that. So that is one thing that they will do. They will start whipping the votes for the floor, and also preparing our sponsors and our supporters to do the floor debate, which is always exciting for Convention of States to watch that.
All right, Catherine, before I let you go, what's the call to action right now for people in Ohio who are tuning in right now, but maybe aren't part of the team yet? What's your call to action?
Yeah, thanks, Andrew, for that. So if you are in Ohio and you are a supporter, we've got two actual pieces of legislation here. HB 67 is our commissioner selection, referred to 34 ready. Call your legislators, let them know you support that, choosing the delegates. And then HJR 2 is the resolution. Call and let them know that you want Ohio to join the list, become the 20th state to pass the Convention of States resolution.
Thank you so much, Catherine. Y'all just do amazing work in the Ohio legislature, and just thank you for doing all that you do to get this team to become state number 20. So we'll have to have you back when we hear opponent testimony. I know it's always difficult to hear that, but you always have a great perspective on what our opponents say. So we'll have you back soon. In the meantime, we got a country to save, Catherine. So it's time for us to get back to work.
Amen. Thanks, Andrew.
All right. Thank you, Catherine. Thanks for tuning in, everyone. We'll see you next time.